Hi guys, welcome to my channel. My name is Diana Romanovska. I am a certified family law specialist practicing family law divorce in the Bay Area, California. Finally, the video about Kim Kardashian. I was waiting for something to happen about her case. So, the news of today, as of November 29th, she settled her case right before the deposition and is receiving $200,000 a month in child support. How come? Well, as you know, or don't know, if you didn't watch my videos, child support is a combination of many things. First of all, the court uses so-called master calculator, and it consists of, you write how many children, then what is the percentage of visitation, and my understanding is that she has 80% of the time and they just pick the number 80-20, although he has equal access to the children, which means it's vague, we can talk about it. So let's say 80-20, and then we put their income a month, and then some deductions for property tax, very minor deductions, and then if they contribute to 401k, and then that master calculator will deduct how much they pay in taxes, California and federal, and then it will calculate net cash flow and the amount for child support. And I blocked out spousal support because they have a prenup and they don't, applying this prenuptial agreement, meaning they don't contest it. So I blocked it out. And if I put number, let's say $2 million a month for his income and $1 million a month to her income, I don't know who's making, I just made up numbers to come up to 200,000. That's when it would be 200,000. If I put 1.9 on his side and 1.9 on her side, he still will be paying $178,000 a month. So really, the difference of whether she makes $1 million or 1.9, the difference is about what, $22,000. Incredible, right? When it goes to this type of level of income, the difference is minor. Now they have 4 children and they're all minor, and I put under her filing status head of household. So it makes a difference because she gets deductions. Now, percentage, the 20%, if you don't know how to calculate it and you don't have a master that I have and court has, it's available if you type it in Google, child support calculator California, and then the first website that ends with GOV, when you click on it and then start, calculate child support start and put how many children, and then when it says percentage, you can click on advanced, and then how you will be able to see, for example, every other weekend would be 14%, or you will be able to see how the percentage is calculated. And if you have a unique schedule, let's say 1 day a month, and it's not on the list, then you go at the bottom and click 1 day, and then there's a scroll down menu, 1 day, a month, an hour, a week, and then you pick your options and then click OK, and it will automatically calculate the percentage. So that's how you calculate percentage. Secondly, add-on expenses. So we have child support, which is designed technically for shelter and food, doesn't include any activities, doesn't include medical, doesn't include nannies. That's separate. So child support, 200,000, then 50-50 child add-on expenses. It consists of 3 things. Number 1, nannies, meaning child care while one parent who has the child is working. So let's say if he got 1 week and she got 4 weeks and both of them are working, then they both would be splitting the cost for nannies. The second thing is the cost for visitation. So if, let's say, she's in California and he has to travel, take a plane, hotel, then she would be contributing 50% of his reasonable visitation. It depends on their lifestyle. And then usually it's not really enforced. I haven't seen people, they say, okay, I will contribute and then they determine the amount, and the other person can choose lavish or not, hotel and private jet, whatever. So usually it's not split 50-50. I haven't seen that in practice being done, but technically that exists. And then the third thing is out-of-pocket medical expenses like braces and things like that. So that is add-on expenses. And remember, nannies only during the time when a parent is working. So now the question is, what if Kim Kardashian, what if he's working 80 hours a week? Would they have to pay during the time they have the children for 80 hours a week nanny? I had cases where, yes, the court ordered you have to. Technically, my argument was, well, why would you? First of all, I would like, as a parent, to exercise a right of first refusal. If the other parent is to hire a nanny and have me pay for half of 80 hours a week, I would like to have a right of first refusal, meaning if you can't spend time with children more than a day or more than 6 hours, if you know you will be working for 8 hours, let's say 8 hours, then you need to call me and I will take them over for 8 hours. But then I cannot ask the other side to pay for my cost if I'm working and have a nanny. So, it gets complicated. So judges don't like right of first refusal, because then if the couple is not very on good terms, then it gets messy. And so I would stay away sometimes from right of first refusal. But in that case, the court ordered, 80 hours a week of work is fine. And I think in Kim Kardashian's case, if she has to work 80 hours, he has to pay for half for the nanny cost. Now, extracurricular activities. That's where joint legal custody comes to place. Why would we have joint legal custody if she spends 80% of the time with children? Well, if she signs up kids for many activities, he has to pay for half of it. And if it's joint legal custody, then he wants to say potentially no to some activities if he doesn't want to pay for it. So if she had sole legal custody, then she would get reimbursed 50%, whether he says yes or no, it doesn't matter, because she's sole legal making decision about their life, activity, school, medical, everything. Okay, so that's split 50-50. If joint legal custody, they have to agree. If she gets sole legal custody, then she still can get 50% even if he doesn't agree. All right, so prenuptial agreement. They cannot waive child support. Prenuptial agreement would be the section where if they waived it, it would have been invalidated because child support is not possible to waive. It's against public policy. Sometimes children are not even born when prenuptial agreement exists, and the children didn't sign, and they shouldn't suffer if one parent makes a decision against their best interest. So that's the background understanding for why child support is not enforceable. I'm surprised, actually, spousal support, well, not surprised, because, they're making a lot of money, so they can waive spousal support, but recent trend is that courts do not enforce waiver of spousal support. The court ignores it and orders temporary spousal support. Go figure. Why would we have a prenuptial agreement and spousal support waiver if it's not enforceable? So be aware of that. Custody. What is legal? What is physical? Legal custody is who is making major decision about medical, religious, school, all of that. And in cases like Kim Kardashian case, they agreed to joint legal custody, meaning they would make joint decision about their life, including private school and things like that, so that he can participate and he would pay. It's rarely that the judge would give sole legal custody to one parent, unless there is domestic violence restraining order. And even then, a year later, the abuser can come and rebut and say, I changed. I'm a better person now. I have done 52 weeks of better intervention program. Or if the other parent who asks for sole legal custody is not only a victim of abuse, but victim of drug abuse, if the other side is completely unfit and takes a lot of drugs, then it's not in the best interest of children to have joint legal custody, because mother needs to get them to the doctor appointment. She wants to enroll them to school. She doesn't want to wait for a drug addict father or mother to be available to respond to emails and sign applications. All right, so we talked about custody, visitation, equal access. So they agreed that he will have equal access. This is similar to when I had cases where they would agree father has reasonable visitation, meaning he calls up, he's like, hey, I'm in town, I will be here in 48 hours. Can I have the kids for the weekend? Sure. It's done when parents have completely unflexible schedule, meaning for her, for example, he probably has to travel a lot, she's busy, and they don't want to have rigid schedule where it would be applicable for parents who have 9 to 5 schedule and very predictable schedule. So how did they pick 20%? Go figure. They figured, he might come in once a month for a weekend and take them for summertime. Maybe that's how they came up with 20%. I think they set it arbitrarily, just for the heck of it. Mediation. Why would they do mediation? First of all, mediation is private, meaning we don't get to see what really they agreed on unless they filed mediation agreement, which technically they don't have to do because it's a contract, it's not an order. After each mediation, I like to prepare mediation agreement, or it's called marital settlement agreement. We can file it, we don't have to file it. It can become part of the judgment package, doesn't have to be. It depends on the client. Sometimes they don't want to make it public, so we don't file it. It's less expensive. If they went to trial, if they wanted to set aside the whole prenuptial agreement about spousal support, it would have been so much publicity for Kim, but probably it's also stressful. And I think she's the one who passed the bar. She knows how it goes. It can go drag on and on and on like Amber Heard, and she can lose money by being tied up in trial and potentially win some, but the consequence of being sucked in trial is not making money. It's stressful. So people choose private mediation for private reasons, for cost reasons, stress reasons, and they have power. In litigation, could have lost the set-aside of spousal support waiver provision if she makes less money than him, I assume. I don't know. Maybe it's not true. I'm just making assumptions here, so I don't have all the facts. Then, in that case, she could have lost, and he would have gotten prevailing party attorney's fees, potentially, because the prenuptial agreement usually has a provision called prevailing party attorney's fees. If you challenge this prenup, you have to pay reasonable attorney's fees. In their case, what's reasonable, can be decided by the judges. It can be millions of dollars if one party loses the fight about validity of the prenuptial agreement. So I'm sure that all of it was consideration going into private mediation. Now, in private mediation, one party might say, I don't want to do it. Then there are two options. They could agree that the mediator will be private judge or a different private judge, or they go the court route. Again, court route is public, nasty, lots of publicity, maybe not wanted publicity. Private judge is in private, it could be even over Zoom. Sometimes we have a judge making a decision after the judge was our mediator without us having to even make it a court case, meaning we don't have to appear and present our case. The judge knows the case, makes a decision based on what the judge heard in mediation. Well, finally, how come they settle right before the deposition? It does remind us on Elon Musk how he settled his case, his fight with Twitter right before the deposition. What is deposition? Deposition is a discovery tool that lawyers use in order to get information that they can present in trial. For example, how much is he making? What is he doing? Any question can be asked. And even if so imagine deposition is done either over Zoom or in person. There is a court reporter who transcribes everything that's happening. I'm the lawyer who, for example, asks the questions. And because there is no judge to say, well, this question is irrelevant. Let's say I ask the question and opposing counsel says irrelevant, which is not a proper objection in deposition, by the way, but it happens all the time. Or they say leading or whatever the objection is, asked and answered. Because there is no judge to say sustained or overruled, this objection is recorded, but the other side has to still answer the question, and then the judge can decide later whether this question was appropriate, vague, compound, whatever that question was, and then strike it from the record. But I can get all the answers. So I love deposition because I get to hear the story, I get to know the facts, I get to see the credibility of the other side, how the demeanor is. Are they going to be successful if as a witness? Are they credible? All of it is amazing tool. The disadvantage of being deposed is it's being exposed. I can ask any question. Imagine, did you make money 20 years ago? Well, it's irrelevant. How much? With whom? Did you cheat? I mean, I can ask anything, right? Technically, it's irrelevant. It's against public policy. California is a no-fault state. It doesn't matter, but I still get to ask. And I'm entitled to an answer. So people hate to be deposed. And that's why they get out, right? Right before the deposition, either because they want to be exposed, they don't want to answer the questions because it's going to be eventually public. Most of my cases, I have to say, settled after the deposition, right after, because when I depose, I expose them to the level where they think, okay, well, actually, I better settle, because I ask from so many angles that they realize the position is not as strong as they thought it would, and that's how we settle. Sometimes we settle right before the trial. That's also happening often, but deposition is a good one. I hope that was helpful and entertaining. If you have any questions, ask them down in the comment section below. I will see you in my next consultation. Bye.